check. It's March 2nd, and I started the stream with my microphone unplugged. We're getting a good start to the March Madness. What do you think, ladies and gentlemen? Welcome to the Court Gallery. Thanks, R2. We needed that. Can't catch a break. You know, who knows? R2 may speak up again before it's all said and done. Ladies and gentlemen, welcome to the Court Gallery. We're starting in Michigan and going to Texas. It's Judge Middleton and Judge McNally, Judge Stevens, and Judge... Oh my God. How did I forget her name? Oh, wow. That's embarrassing. It all starts right now.
Mr. Wellington, why don't you come on up and have a seat with your attorney? Next up this morning is People versus Kyle Michael Wellington. Is that you, sir?
Yes, Your Honor.
Here with your lawyer, Mr. Paul Gibson. Also present is Abby Stoll from the prosecuting attorney's office. File number here, thank you, Paul, is 26112FY. People versus Kyle Michael Wellington. Mr. Wellington was originally charged on a felony complaint that alleged in January, the 11th and the 21st of January 2026 in the city of Three Rivers that he did assault Amanda Lee Maston, aggravated assault as a second offense, which makes it a felony punishable by up to 5 years imprisonment. The defendant pled 2 counts of domestic violence. On February 17th, the matter was set for sentencing today. Ms. Maston is present, which is helpful. So I took the plea on February 17th. We set the matter for sentencing today. I wanted a chance to get the police report and get victim input. I did get the police report and the complainant is here. So Mr. Gibson, what would you like me to know?
Mr. Wellington showed me an email that he received. It looks like he has obtained employment at American Axle. The email indicated that he's supposed to start today. It's my understanding that the victim in this case is asking for the no contact to be lifted. I believe that this was an unfortunate, these were unfortunate situations, and I believe that the defendant can learn from this, and I believe he can be rehabilitated. I would ask the court to consider as a sentence probation, community service. If there's jail time, I would ask the court to consider work release to allow the defendant to work to start his new job, or to consider weekends that would allow him to work. Thank you.
Ms. Maston, would you come up, please? Thank you for being here. Are you Amanda Maston?
I am.
And you're the complainant in this matter, and it's alleged that these things happened over a period of time in January. My sense from reading the report and reading the affidavit of probable cause is that this wasn't a one-time thing, but a pattern of discord and abuse. You broke your finger, and I wanted to know, among other things, whether you had unpaid medical expenses. So what would you like me to know?
Sorry. Yes, my finger did get broke.
Now, as you're sitting here right now, it's March 2nd. You've got a cast or a brace on your finger. Is that as a result of this injury in January?
They had to put a pin in my finger last Wednesday. Had they not put the pin in, the tip of my finger would not extend straight, and I wouldn't be able to use the tip of my finger. And I work a lot, so I need my hands to work.
Okay.
But
go ahead.
The way that the report is written from the officer, it's not accurate. There's flaws in it. Like, I need him home. Like, I understand, like, everybody makes mistakes in their life, but like, it was partially my fault too. But like, I can't shower, I'm not supposed to drive. Like, I need him home.
Because of the injury to your hand? You can't shower because of that?
But I can't get it wet at all. So
Can't
like,
you put a bag over it or something?
yes, but like, I still need some help. Like,
Okay.
I still have kids to take care of as well.
How many kids are in the home?
2. Well, one's 19 and one's 16.
And where do you work?
Right now, I'm not working.
Where did you work?
McDonald's.
Did you have to take off work as a result of this?
No, I worked through it.
He's been living in Buchanan?
Yeah.
All right. He had some methamphetamine issues in the fairly recent past. Is methamphetamine a pink elephant in the room here?
No.
Methamphetamine's not an issue presently?
No.
How about alcohol?
No.
Well, let me read what you told the police, or at least what they put in the report. Amanda Maston was identified verbally and interviewed in the interview room at Three Rivers Police Department. On January 11th, she was in an altercation with Wellington. She was trying to leave for work and asked Wellington for the car keys. He was not being cooperative, and she thought they were in his book bag. She grabbed the bag, and Wellington tried to rip the bag from her, and the force threw her and the book bag to the ground. She explained that her finger was in the loop when he threw the bag, and she did not let go. She landed face first on the porch with the book bag. After she fell, Wellington told her the keys were upstairs by the TV on the counter. Wellington drove her to the hospital in Dowagiac to seek treatment from the injury, so she could not tell the story of what happened. She stated the hand specialist asked further questions about the situation, and that's where the referral came from. She had her medical records and handed them over. She advised that on January 21st, Wellington assaulted her again. She stated that she was sleeping. She woke up to Wellington calling her a liar and a cheater. She believed that if he believed that, he could leave. She was trying to get up and leave the room, and he was not letting her pass. She stated when she tried to move past him, he tackled her on the bed and pinned her down. She explained that he had a hold of her neck with one hand holding it down and proceeded to show me a bruise under her ear on her neck. The bruise was consistent with a thumbprint. She continued to state that she blacked out after that due to the anxiety of the situation. She felt she could not breathe due to pillows and blankets on the bed, not from being choked. She advised she then noticed a long red mark on her chest that was not there until the incident of the 23rd, she believed that when she blacked out, Wellington must have caused that red mark. Masson advised that the physical assaults are getting more frequent and happening once a week. This is your house, and he was living there. He has a previous domestic assault charge, and neither of those incidents involve drugs or alcohol. All right, Mr. Wellington, what do you want me to know?
I've never hit her. I promise. I've never, the most I've ever done was calm her down. She got angry at me once and went to snatch the phone, and that's when I held her down. Like, you know, I've never hit her. I promise. I've not gonna assault her in any way.
Well, you entered these two pleas. Do you want me to continue to proceed to sentence?
Can I be honest with you?
Yes.
I didn't know how it was going to turn out. Yes, I did snatch the book bag out of her hand.
All right, which resulted in her finger getting broken?
Yes.
Okay, well, that one's pretty good. All right. The other one, you're saying you were actually holding her down, but that is an impermissive touching. Do you want to continue your plea to these two misdemeanors?
I don't want to get. My luck is I'll take the trial and something's going to happen where I don't know, and I'm facing 7.5 years.
Yes, that are felony charges. She says you assault her once a week, that you're angry all the time, and that she's in an abusive, assaultive relationship. Certainly, she got a significant injury to her hand. But you are correct. The prosecutor dismissed the felony charge for a plea to the misdemeanors, and that's.
And my first domestic was my ex-wife wouldn't let me leave the house, so I moved her out of the way, and she called her sister. But
well, that was 13 years ago.
Yes, Your Honor.
Abigail, what's the prosecutor's input here?
I would object to the defendant withdrawing his plea. I believe there needs.
Well, I'm not sure he's asking to. You're not asking to withdraw the plea, are you?
No, Your Honor.
All right, go ahead. But if he did, you would object.
Well, I guess then my sentencing recommendation would be, I mean, Your Honor, so this was reduced from a felony to a misdemeanor. The defendant does have a prior domestic violence conviction. It's clear that he's not taken any accountability. He told the officer during his interview that he's never hit a woman, and told you just now that he's never hit a woman, and clearly that's not the case. He has a domestic violence prior. She's sitting here a month later with her fingers still in a brace. The officer also noted after the second assault that she had bruising on her throat in the shape of a thumbprint. I guess I would recommend at least 21 days in jail, as well as a lengthier probation. I would recommend 24 months. Thank you.
Tell me about your job at American Axle. Is it with PTI, the aftermarket place in there?
Quality control.
What's it called?
Quality. The position is quality inspector. I mean, sorry. She called me Friday or Thursday with the phone interview.
Is this through a temp agency?
Oh, I have no idea. I'm not familiar with.
Well, how'd you get hired? Did you apply?
I filled out tons of applications.
Okay.
I don't know who that email. He showed me on his phone. It's on his phone. What is it? Says Jessica Beck, AANTI.
I'll be reporting to Zachary Helm.
Let me see here.
Oh, okay. PTI.
Oh, yeah, it's TTI. Yeah, PTI. Is that a temp agency, PTI?
No, he got arrested on the 23rd and he bonded on the 29th, so he's done 6 days in jail. I'm gonna do a 24-month probation, which means you can be discharged at the end of 12 months. Motor 10 days, jail credit 6. And we'll do the other days on weekends. Fine is 0. There's a $75 crime victims' rights fee and a $50 state minimum fee, $150 attorney fee, $960 probation oversight fee, and you're to pay for the class. I'm putting you in the full domestic violence class. There's something going on here, and I don't know that I got to the bottom of it. My fear is that there's a methamphetamine component that I'm not picking up on. If I give you a test right now, what would it show?
Try positive.
For meth?
Yeah.
All right, well, you're gonna stop using it. I think meth is underlying this. We're gonna get a test to figure out what's in there, and then we're gonna get it to 0. No assaultive or threatening behavior, to abstain from the use of any drugs and alcohol, including marijuana. I'm gonna have you go to the day reporting center today and test. If you're positive for meth or marijuana today, I'm not gonna lock you up. But I want to figure out what your benchmark is. I appreciate your candor. The methamphetamine is still lurking in the background. Do you have to take a test, a urine test, a drug test to get hired?
I'm not sure.
I don't know. We'll find out about that. I got a year hang over your head. And you did 6 days. The no contact provision is lifted. So you can get back together. You can't engage in any assaultive or threatening behavior. I'm just gonna lock you up. I think you're gaslighting her. I think there's more going on here. You're saying, I'm just calming her down. You got anger issues. And you're minimizing it. So I can always flip the switch and just give you 90 or 365 days in jail. But I want you to do our domestic assault class. No assaultive or threatening behavior. Abstain from all alcohol and prohibited controlled substances. I want you to go to the day reporting center as soon as you leave here. Do you know where it is in Three Rivers?
No, I can GPS it.
It's on South Main Street, just south of downtown on the right-hand side. We'll let them know you're coming.
Yeah, yeah. What do you think?
Do you have any money with you?
No, sir.
Well, we'll figure that out. Let's add up what you do owe. You have been making payments on your other stuff. You also got a speeding ticket earlier this month, but you had some other unpaid stuff and you've been making payments as recently as February. You've paid on your other stuff. So let's 125 plus 150 plus 960 plus you to pay for the class 1235. I think I may have some bond money in here. Let's take a look. I have $500 of bond. I will use bond money. for first DRC test. So if you do this in 6 months or 12 months, it'll be reduced in half to 480. So take 480 off of that, and you got $500 of bond. So you're not going to owe that much money, but I'm going to save some of this bond money to pay for your first test at the day reporting center. So I want you to go out to the counter. I'll get you started as a probationer. You're allowed to have contact. You're allowed to move back in together. No drugs, no alcohol. And I think you're gaslighting me too. I think you know there's a methamphetamine problem and you were afraid to tell me that. If we can deal with that, maybe we can deal with the rest of it. You're gonna owe 2 weeks. We got time to fit that in. Main thing is I want to get you clean. If we can't, we can compel that with a jail sentence. But mostly, I don't want any assaultive or threatening behavior. She wants you back in the home. She needs your help. She needs you clean and sober, and so do these boys that are living in the house. So you take this out to the counter, and I want you to go to the day reporting center. We need to let DRC know that Mr. Wellington is coming before noon. We'll get a benchmark test and see how we're doing. All right, you go out to the counter and we'll get you started on probation. This is not deferral eligible because you have a previous domestic violence conviction, but I do think you could benefit from the class.
Thank you, Your Honor.
Thank you. Thank you for being here, Ms. Manston. This is file number 252290SD. Are you Ruth Jane Minkle?
Yes.
Here with your lawyer, Mr. Timothy George. Also present is Abby Stoll from the prosecuting attorney's office. This was originally charged as operating with a high blood alcohol level. The matter was reduced to operating while intoxicated, which is going to cause your driver's license to be suspended, which is going to be a hardship for you. Somebody has given me an AA log and a letter, couple letters. Excuse me just a moment. Yes.
Could we bother you to get the headphone set for my client?
No. Laura, could you help us? No bother at all.
While we're getting that, Your Honor, we did provide a letter of support, a letter documenting AA attendance, and then also some AA log, as well as a certificate of completion and a pivotal assessment from last year.
Could you help her with the headsets?
Absolutely.
This was Michelle's area of expertise, but she's not with us, and Paul.
So this young lady over
Yes.
here? I'm gonna have to play around with that.
Thank you.
Okay, let's see if you.
Which is right or
I
left.
don't think, it doesn't matter on those, I don't think. Okay, let's see.
Oh. Oh, yes.
Can you hear me now?
Yeah,
Okay,
Very
good, I got
good.
you on the right channel then.
Thank you.
thank you.
You're welcome.
All right, Mr. George, what would you like me to know?
Thank you, Your Honor. And I think one of the things that has struck me most in my representation of Ruth is her insight into what led her to this very troubling situation. I know she is absolutely horrified by what happened, that she allowed herself to be in a situation to put, the community as a whole at risk. But, as I had recently mentioned, fortunately, she's here with no further issues other than the alcohol and driving. My client's been dealing with a significant substance abuse issue for a number of years, and she has taken a lot of steps, and she provided me a lot of documentation about what all she's gone through really over the last 2 decades, including treatment, inpatient treatment, therapy, counseling, AA, substance abuse evaluations. She's really found a way on her own to handle the significant issue. She's had significant losses that she's dealt with. She's lost 2 husbands over the last 2 decades or so.
25.
And those have been significant triggering events. And fortunately, she's been able to, through her treatment, handle those. I think you find my client now as someone who's alone in a lot of ways. She does live by herself with her cat, and doesn't really have much in the way of family in the area to lean on. But she does have a neighbor here who's helping her out. And I think at its core, Your Honor, you're dealing with a very intelligent individual, very educated individual that realizes what she's dealing with. And I think there are circumstances with the Ativan that she was taking at the time and having, uncontrollable shakes, and felt, if I can just have a drink, then I can get rid of those shakes. Well, it did that, but obviously had a more profound impact on her. And I know that she's terribly sorry about that and wishes that she could go back and change it. On the positive, she does report to me that she has not had anything to drink since the date of the offense. She reported that she just had her 3-month coin that was given to her, and she's immediately plugged herself back into services. So all in all, Your Honor, I know it's the facts are not great and it's not a great situation, but I think before you is someone who understands the level of addiction that she's dealing with, someone that's been doing the right things for a long period of time, had this issue, but then plugged herself back in and is continuing to do the right things. I think based on those factors, Matt's recommendation is appropriate. It allows her to continue on with everything that she's doing, probably adding in the testing, and we talked about that a little bit today. But I don't believe that this is a situation where any additional jail would be appropriate. I think she understands the significant nature of the offense, and we'd ask the court to adopt Mr. Huff's recommendation. Thank you.
Abigail, what's your thought here?
Thank you, Your Honor. I also believe that the recommendation is appropriate, and I would ask the court to follow it.
Ms. Minkle, what he's recommending is that I give you 7 days jail, credit for the 2 that you already did, and defer 5 days, not order any additional jail at this time, and put you on a probation where we supervise your attempts to get to sobriety. So you're an interesting case to me. I've been here for a long time. You and I are about the same age, and I feel I know everybody, but there are lots of people that I don't know. They don't get in trouble. They don't come to court. They don't come here. And you've been silently in desperation, struggling with alcohol for years, but you've never come to the attention of law enforcement. Can you hear me?
Yes.
Okay.
I was just asking for Kleenex, Your Honor.
Oh, yeah, we moved them from the plaintiff defendant side to the other side. Thank you.
Thank you.
So Constantine's not your town, but now it is your town.
Yes. Yeah, sure.
Constantine is the kind of place where they would claim you.
Yeah.
You would find neighbors to help you. You would find a community. Sounds like you're involved in the American Legion.
Yeah.
Was your husband in the military?
He was in Vietnam.
I think you
Both
told.
husbands.
I think you told me that at the time of your plea. So there's a real community there at the American Legion.
Yeah.
And so I'm glad to know that you've got some friends down there. It's a tight-knit little town. But this was bad. And you heard me talk about 131 and the big hill and what you were doing. And it's just by divine intervention, that there wasn't a fatal accident involving you and or somebody else.
Praise God.
But I think this was a big eye opener for you. You accepted responsibility. And you're plugged into AA. Now you're doing all your AAs in Constantine?
Yeah.
Because it's most convenient?
No, I'm a very loyal person and I just like, it's like my family, so that's.
Well, did you do Constantine previously?
Yes, I did.
All right.
During my,
Well,
yeah,
there's another community, and I'm the sobriety court judge, and we've got some people in our sobriety court group that are doing their AA in Constantine. I know one of the guys that signed your letter, Paul,
yeah.
and I'm very glad to know he's in that community. Tell Paul I said hello.
Well,
And Rebecca and some other people that I hope are still plugged in down there. Rebecca.
I'm the only woman now. But
All right. Anyway, that encourages me. You got some support here. You got American Legion friends and associates. And you got your AA family and associates.
Your Honor,
Yes.
can I talk?
Yes, this is your turn.
Oh, I also go to the gym because when my husband passed away, I found myself totally isolated. And we just moved. We just retired and bought the house. When he passed away the year after, so I didn't know anybody very well. I didn't, so part of that isolation in the house over the years, over these past 9 years, I just made alcohol my friend. It was my medicine at home, in the
Yes.
house, isolated. And it just went downhill. It just got worse. So I sought help. I mean, I knew I had a problem and I went for help,
Now you have some stepchildren. Are they involved at all, or they are live
They're
somewhere?
all in different, well, two of them, one's in Chicago, one's in North Carolina. The other one's in Detroit. My stepdaughter's in Detroit. They never get this way unless they go see their mom, because I'm the stepmom.
Mhm.
And they go to Niles. So I get on okay with the mom. We always bonded, we were all right. So she calls me up and I go, when the kids come, I go there, and that's really the only time I ever see them.
All right. Well, this is going to extend your life by years.
Yeah.
Not to mention if you hit a tree going somewhere, but literally, if you can get over this hump,
Yeah,
it will extend your life by years.
yeah.
But I'm going to follow Matt's recommendation.
Your Honor,
Yes.
I just want to say that when I've been sober, that my strength has come from the Lord, and I'm very, very, I think that's what has actually kept me going and kept me strong when I've been sober. So I've got closer all these years to the Lord. And so.
Well, I've only met you when you're sober. So, like I said, you've been there in quiet desperation.
Yeah.
What part of England are you from?
I'm from Lancashire, a place called Blackpool in Lancashire. In fact, your name is very prevalent to me, Middleton, because my mother was born in a town called Middleton in Lancashire. And the town was owned by the Middleton family back in the 1800s. And so they called the town Middleton. And it's like about 25 miles from Blackpool. Blackpool's on the coast. And my grandma was Irish. That's why I was agreeing all the time. She was from County Cork.
My family came from England
Yeah,
to Canada,
yeah.
and I was able to obtain, with a gracious help of one of the people that views our channel, my family history. And my great-great-grandfather, Isaac Middleton, great-great-great-grandfather, came from England to Ontario in 17,
Yeah,
I don't know, anyway. So anyway, I may be related to those
you
folks.
probably are.
My people weren't the kind of people that owned the town. They were the kind of people that worked for the people that
Yeah.
owned the town, but,
Well, my grandfather worked on the mines, so coal mines, so he,
I'm gonna do a 12-month probation, 7 days jail credit 2, leaving 5 days to serve, but if the 7 days ordered, 5 are deferred. I'm gonna reduce your fine because you're gonna do this probation. Fine is 0. There's a $75 crime victims' rights fee, a $50 state minimum fee, $100 screening fee, $150 attorney fee, $480 probation oversight fee, a $200 reimbursement to the sheriff's department. And I'm really glad nobody was hurt.
every time I pass, Your Honor, every time I pass that road, I have to go to the grocery store that way. I feel sick every time I pass the road thinking about what could have happened. So I'm very aware, I'm very ashamed of it.
Well, we'll get over it. It didn't happen and we'll hope for the best. Also, I'm ordering the victim impact panel along with our last young man. There's no bond to apply here. If you do this in less than 6 months, it will reduce the bond by $40 each month. I'm ordering substance abuse counseling and treatment support group, alcohol and drug testing at random. You attend the victim impact panel. You're not to use any drugs or any alcohol. Drugs are not an issue for you,
Nope.
but certainly you're also combining alcohol with Ativan and your other prescription medications,
No.
which makes it even worse. You can take all your prescribed medication.
Yeah,
You just can't.
I went to the doctors and told the doctor I want it red flagged. I don't ever want that stuff again.
All right. I think you're going to be a cooperative and ideal probationer. You're going to do what's asked, and I think Matt will. You'll find he's going to be easy to work with. But I'm serious. If you stay on this course, it's going to significantly shorten your life. Our age, we don't have that much of it left.
No, and I've had cancer twice, and God has brought me through it. He must have something in mind for me.
Well, maybe you can be a role model for somebody else.
That's what I'd like to do.
Now, one wrinkle here is you're going to lose your driver's license for a period of time. I don't have any control over that. That's by operation of the law. I had people in the past who volunteered to, I didn't do the community service. 20 hours of community work service. You could probably do that at the American Legion.
Yeah.
I had some people in sobriety court that did their community service at American Legion. They'd show up every Sunday and help at the Sunday breakfast.
That's what I do.
Then they just kept going. So they finished their I think they might still be volunteering there.
I've been doing it for 10 years.
Yeah. So for you, it's just going to be, and it gets you out of the house. It's a sense of community. There are good people there. You can't sit in there. Alcohol will weigh heavily on your mind. You need to be out. You need to be engaged. You need to be doing things. All right. I'm going to have Mr. George take you out to the counter. Mr. Huff isn't here today. because he's ill. We are about a week out from setting up the probation office across the street. They're getting the electronic equipment, the computers hooked up in there. They've cleaned those. There are total 4 offices, and we're going to be right across the street. But for now, if you go out to the counter, someone will meet with you. Our probation clerk isn't here today either. Everybody's got some sort of bug. Ms. Minkle, what I hope is that this is successful. I don't hear much more about you other than good news. Say hello to Paul. And everybody else there, maybe you can help them too. All right, you're good to go.
Thank you.
Thank you, Roma. God bless you.
Thank you. I'll take all the help I can get.
David Allen Powell, 26F703461. Lieutenant, good morning. Your name?
Good morning, Your Honor. Detective Lieutenant Chris Rembez, City of Flat Rock Police Department.
Raise your right hand. Do you solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God?
Yes, I do.
Okay, you can go ahead.
Your Honor, on 11/26/2025 at approximately 21:58 hours, Corporal David Goldsmith of the Flat Rock Police Department observed a gray Ford sedan traveling south on Telegraph Road in the left-hand lane of travel. Corporal Goldsmith observed the gray Ford sedan cross over the white fog line and return to the center lane of travel. He then observed the gray Ford sedan cross the yellow line into the turn lane and return to the left-hand lane of travel before getting into the left turn lane at the intersection of Telegraph Road and East Huron River Drive in the city of Flat Rock, County of Wayne. The gray sedan then made a wide left turn and began traveling east on East Huron River Drive near the parked vehicles on the south side of East Huron River Drive. Corporal Goldsmith effected a traffic stop on the gray Ford sedan near the intersection of East Huron River Drive and Seneca Street. Corporal Goldsmith made contact with the driver of the vehicle, David Allen Powell. Powell advised Goldsmith he did not have a valid Michigan driver's license and he was swerving because he was using his cell phone. Corporal Goldsmith made contact with the passenger of the vehicle, who was identified as Bobby Nicole Melton, who advised that she had several warrants for her arrest. Corporal Goldsmith queried both subjects in lien. Powell returned in lien with his driver's license showing revoked. Melton returned with several warrants out of several jurisdictions. Corporal Dane Hunter, also of the Flat Rock Police Department, who arrived on scene to assist, requested Melton step out of the vehicle as she was being detained on her warrants. Officer Charles Porter, also of the Flat Rock Police Department, who arrived on scene to assist, made contact with Powell and advised him he was being detained for driving while license revoked and for having several warrants out of multiple jurisdictions. Corporal Goldsmith requested our dispatch to have Adolph's Towing make the scene to tow the Ford Focus. Officer Porter then conducted an inventory search of the Ford Focus. Officer Porter located a small silver cylinder containing a crystalline substance resting under the parking brake closest to the driver's seat. Corporal Goldsmith then read Powell his Miranda rights. Powell advised he would waive his rights and stated the drugs were Melton's and not his. Corporal Goldsmith then read Melton her Miranda rights. Melton advised she would waive her rights and stated the drugs were not hers but were Powell's. All agencies advised and released on Melton's warrants, and she was released from the scene. Corporal Hunter confiscated the license plate from the Ford Focus due to Powell having multiple prior convictions for driving while license suspended, revoked, or denied. Corporal Goldsmith advised Powell he was under arrest for the possession of narcotics. While in the Flat Rock Police Department booking room, Corporal Goldsmith located a blue-colored glass crack pipe in Powell's front right pocket of his flannel outer shirt. Powell was then booked and released from the custody of the Flat Rock Police Department pending lab results. On 12/11/2025, I received the results of the lab test by the Michigan State Police Northville Lab. Isla Patel, who is an MSP forensic scientist of the seized drug unit, authored the report with the following findings. Item number 1, which was the metal keychain screw top container, contained 0.1435 grams of methamphetamine, a Schedule II controlled substance. Based upon the officer's investigation, the results of the lab test from the Michigan State Police on 12/23/2025, I forwarded this case to the Wayne County Prosecutor's Office for review and the charges which you have in front of you.
And does the defendant have a prior conviction for drive while suspend, revoke, denied on July 26 of 22?
Yes, Your Honor. It's on page 2 of his certified driving history out of the Southgate Court.
Based on your sworn testimony, I find the crimes of possession of a meth and drive while suspend second were committed. There's probable cause to believe the crimes were committed by the defendant and authorize the issuance of the complaint. Have a great day, Lieutenant. Thank you.
Thank you, Your Honor. You too.
Yeah, you too. Thank you.
Quinn Coy Parker, 26B-725-807. All right, good morning, Detective. Your name?
Good morning, Judge. Detective Crystal Tulas, Brownstown Police Department.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
I do, Your Honor.
Okay, go ahead.
Your Honor, on November 18th of 2023 at approximately 4:11 a.m., while in fully marked patrol unit 1821, Officer Bilecki was dispatched to the Sunoco gas station located at 21980 Sibley Road in Brownstown regarding two males in a tan Cadillac Escalade harassing customers. An area search was unsuccessful, and officers determined that this is a suspicious vehicle and individuals were gone on arrival. A short time later, at approximately 4:30 a.m., Officer Bilecki observed a white Cadillac Escalade in the parking lot of that Sunoco gas station. Of the Sunoco gas station located at 20950 Dix Toledo Road in Brownstown. As Officer Bilecki entered the business lot, the Escalade exited the lot onto northbound Dix Toledo. Officer Bilecki observed through the windshield of the defendant's vehicle that the Escalade was occupied by two individuals and that the front driver's side window was illegally tinted. Officer Bilecki followed the Escalade onto northbound Dix Toledo Road and observed the vehicle drift right of the fog line on two occasions. The Escalade then continued north on Dix Toledo Road until turning southbound onto the southbound I-75 entrance ramp. At that time, Officer Bilecki activated his emergency lights with the intention of performing a traffic stop on the vehicle for the window tint and improper lane use violations. Upon observing that the vehicle was not pulling over to the right, Officer Bilecki also activated his emergency sirens and body-worn camera and advised dispatch that the vehicle appeared to be fleeing. At the time of the pursuit began, Officer Bilecki was in Class B uniform operating a black-colored Chevrolet Tahoe patrol vehicle with black and white reflective Brownstown police graphics, which is also equipped with blue and white emergency lights on the front, rear, and sides of the vehicle and an emergency siren. The vehicle continued southbound on I-75 in a posted 70-mile-an-hour zone until exiting on to eastbound Gibraltar Road, posted 45-mile-an-hour zone, and turning southbound onto Fort Street, posted 45-mile-an-hour zone in Brownstown and 35-mile-per-hour zone in Rockwood. At that time, the vehicle had entered a neighborhood eastbound on German before traveling through several alleyways. The pursuit reached documented speeds of between 40 and 50 miles per hour in the 25-mile-per-hour residential area. The defendant drove onto westbound Huron River Drive from southbound Lamont. Once on westbound Huron River Drive, the vehicle turned southbound onto Fort Street. From southbound Fort Street, the vehicle turned eastbound onto South Huron River Drive. While trailing eastbound on South Huron River Drive, Officer Waterworth in Unit 1813 reported observing an object getting thrown out of the passenger side window of the vehicle. The vehicle continued eastbound on South Huron River Drive until turning south at the dead end onto the U.S. Turnpike. While southbound on the U.S. Turnpike, the vehicle turned eastbound on a Strong before turning southbound on a Trombley. The vehicle continued on Trombley before turning back northbound on a North Dixie Highway. The vehicle turned westbound from the U.S. Turnpike back onto South Huron River Drive and continued westbound until entering northbound I-75 again. The vehicle continued northbound on I-75, exiting onto westbound Michigan Avenue. From Michigan Avenue, the vehicle entered on a northbound I-94 before quickly exiting onto Livernois. From Livernois, the vehicle turned eastbound onto Horatio and southbound onto Hammond before turning westbound onto Buchanan Street towards Livernois. From westbound Buchanan, the vehicle crossed Livernois into a parking lot before continuing westbound on Morton Street. While westbound on Morton Street near Gilbert, Officer Bilecki began to notice that the vehicle appeared to be having mechanical issues. The vehicle continued westbound on Morton at slow speeds until reaching a dead end and attempting to turn northbound down an alleyway with a steep approach angle. Speeds during this pursuit ranged from 10 to 100 miles an hour in clear to light traffic conditions on dry road. The log of the pursuit and directions were documented in CAD by the Brownstown dispatchers. Officers Waterworth and Fox also assisted and were in fully marked patrol vehicles and Class B uniforms during the pursuit. As the vehicle was entering the alleyway, Officer Bilecki observed a white male in an orange hoodie style jacket begin to exit headfirst out the front passenger window of the vehicle. He ordered the unknown man onto the ground and observed him begin fleeing northbound down the alleyway. Officer Bilecki approached the driver's side of the vehicle, anticipating the driver to exit out the driver's side door. However, soon realized that the driver had hopped over to the passenger side and was getting out the passenger side window. Officer Bilecki observed a white male in a dark jacket and blue jeans, I later identified as Quinn Parker, flee northbound on foot from the passenger side of the vehicle. Officer Bilecki gave chase and brought Mr. Parker to the ground before securing him in handcuffs with the assistance of Officer Fox. He was searched and placed in the back of Unit 1821. While communicating with Mr. Parker in the back of Unit 1821, Officer Bilecki noticed that his eyes were watery and his speech was slurred. While searching Mr. Parker following the foot pursuit, Officer Bilecki noted the odor of intoxicants coming from Mr. Parker. Due to the fact that there was still another defendant at large in the area, and because Mr. Parker had resisted arrest both by vehicle and on foot, Officer Bilecki did not perform an OWI investigation on scene. Instead, he transported Mr. Parker back to the Brownstown Police Department jail for the completion of that investigation. Upon arrival at the Brownstown Police Department jail, Officer Bilecki read Mr. Parker his Miranda rights or warnings, and Mr. Parker agreed to waive them and speak to Officer Bilecki. Mr. Parker denied taking any medication or having any medical conditions. He also denied that he had been the driver during the pursuit, and he admitted to consuming 4 or 5 beers prior to his arrest. Officer Bilecki administered the standardized field sobriety tests in the booking area at the Brownstown Police Department jail. Each test was explained and demonstrated prior to the administration. During these tests, Officer Bilecki did not observe any indicators on the horizontal gaze nystagmus, but during the walk and turn, he observed that he was unsteady on his feet, stepped out of the starting position during the instructional phase, missed heel to toe, and turned improperly. On the one leg stand, he observed that he had dropped his raised foot to the ground on one occasion. Mr. Parker was read his PBT rights and refused to provide a breath sample. He then refused a chemical test after being read his chemical testing rights off the DI 177 form. A search warrant for Mr. Parker's blood was subsequently obtained and approved by APA Blomers of the Wayne County Prosecutor's Office and was sworn and signed and authorized by Your Honor. Officer Bilecki transported Mr. Parker to the Henry Ford Brownstown Hospital, where a blood draw was completed. Following the blood draw, which was completed according to the MSP lab kit instructions, it was transported back to the Brownstown Police Department and sent to the Michigan State Police Laboratory for analysis. While awaiting that blood result, follow-up investigation was done to determine whether or not Mr. Parker was the driver. Sergeant Smith went to the gas station located at 20950 Dix Toledo, where he was able to speak to witnesses and review, who I believe reviewed surveillance footage. The witness, who was an employee at the gas station, was able to say that the passenger that had been inside the Escalade that was stopped by Officer Bilecki was a skinny white male with a beard wearing a t-shirt or tank top. that was light colored and had that person in the passenger seat had a spider web tattoo on his elbow. Mr. Parker did not have any spider web tattoo on his elbows, only had a mustache and chin hair, not a beard. And he was arrested wearing a dark colored t-shirt, which led Officer Bilecki to believe that Mr. Parker had indeed been the driver. Subsequently, the MSP lab results came back. The blood results showed that Mr. Parker had a BAC of 0.07 grams of alcohol per 100 milliliters of blood. Mr. Parker has previously been convicted twice of operating while intoxicated offenses. The first on January 20th of 2021 out of the 33rd District Court. He was convicted of operating while intoxicated, which he pled guilty to. And then again on December 9th of 2020 out of the 33rd District Court, he pled guilty to operating while intoxicated.
His license was suspended, I believe you said, correct?
Yes, I'm sorry. It was revoked at the time of his arrest with 2 prior alcohol-related convictions.
Based on your sworn testimony, the court finds by a probable cause standard that the operating while intoxicated was committed. There's a sufficient information to enhance giving rise to the OWI third offense notice, given the fact that he has the 2 prior alcohol-related convictions as described. Also that the defendant committed the crime of fleeing elude fourth and drive while suspended, revoked, denied. Court finds there's probable cause. I'm changing the date. You sent it in February 27th, it looks like. At least that's the day you signed it. And of this year. And then I'm changing that date since we did the signing on record today, March the 2nd. Out of curiosity, when was this submitted to the prosecutor's office?
Your Honor, it looks like it would have been submitted on, at least according to the investigator's report, on November 19th. And we just received
November 19th of what year?
I'm sorry, 2023. And we just received the prosecutor's signed warrant pack back on February 25th of this year.
So they didn't send, it took them roughly 16 months. Okay. I'm putting it in lean. Thank you.
All right. Thank you, Your Honor. Have a good day.
You too. Thanks a lot. Jared Miracle. Jared Andrew Miracle, 20T-635-153A, 20T-635-153B.
Good morning, Your Honor. Attorney Corey Westmoreland appearing on behalf of Mr. Miracle. Mr. Miracle will please take the full name for the record. My name is Gary Andrew.
To what do we owe this in favoring with us with his presence today on a case out of 2019?
Your Honor, I would like to know that Mr. Miracle was in custody in about 66 months.
Oh, actually, we have another one at 18F225650B.
I believe he was.
Did you have proof that he was in custody for 66 months?
I got a DOC card, who called my parole officer. I don't have any proof on him.
When did you get out?
July 15th
What year?
this year.
25.
Wait,
Why did it take you 7 months to come in here?
I just now started a decent job and got to working, making some money. Got money to bring in. I got paycheck stuff to show.
Does he stand mute and waive formal reading, at least on the OWI, and drive while suspend?
That's correct, Your Honor.
What was he in custody for 66 months for?
I believe attempted robbery.
Fault if I said to around a lot.
It's not good.
I was getting bad life. Pretty sure last time I think he told me I would end up going to jail for a lot sooner or later.
Well, I mean, I wasn't wrong, was I?
No, but it saved my life though.
What's that?
It did save my life though.
Does he have the money to pay on 18F225650B?
Your Honor, he has $300 cash to go today. And he gets paid on Thursday.
So if he would have written me a letter, I would have given him credit for his time served on the criminal charge where he hasn't paid it. So I will do so here.
Explain that to him. Yeah, no.
I was unadvised, even through the whole trial in Mineral County. Nobody else brought this county up at all.
I don't know why they would have been worried about this case when you were facing robbery unearned. Okay,
Well, I mean.
I've been talking about the dry well suspend that you owed money on. How many drunk drivings have you had?
That's what we already got. Driving was suspended. And they're all before the permission.
Give me 1 second here. $3,010%, no contact with prosecution witnesses, no alcohol, no marijuana, no illegal drugs. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I will give you a pretrial date. Pretrial date will be March the 26th at 10:45 a.m. Where do you work?
Metro Cleaning.
If you can't afford your own lawyer, then
You feel the protection.
yeah, okay, good enough. So I'll look at that and I'll determine whether or not I'm going to appoint you a lawyer. Do you understand? Don't play this game with me with not showing up. Do we understand?
I'm sure I'm a changed man.
All right, what do you have here, John?
Where did you meet with Sharp?
So you're gonna go down the hall, sir? You are going to get your notice and we'll go from there, okay?
Thank you, Your Honor.
Thanks a lot. Oh, I'm sorry, John, this one too.
Ladies and gentlemen, we've had a call-in raid, and this is your obligatory call-in pause. We're in the middle of a potpourri, and in the midst of the potpourri madness, we are with Judge McNally in Woodhaven, Michigan. He has just done a few swear-tos and dealt with a guy who hasn't shown up for 7 years because he's been in jail because he tried to rob somebody allegedly. And we're now moving on to some other matters. I believe we're picking up with maybe one more swear-to, going into a civil matter, and some pro se surprises before we get our way into Beaumont, Texas for the rest of the evening. Ladies and gentlemen, this has been your obligatory call-in pause, and now back to our programming already in progress.
Are you ready to go on this?
Put it up there.
Adam Samaj Amistad Carlisle, 26B 722-447. Is this yours?
No, sir. Adam Carlisle.
Yeah,
Oh, it's not Humber. I'm sorry. You're right.
that's all right. Okay, your name?
Sergeant Eric Mott. All right, stop this.
Okay, Sergeant, raise your right hand. You solemnly swear affirmative penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
I do.
Okay, go ahead.
On October 6, 2022, at approximately 16 hours, Officer Mott was dispatched to the lobby of the Brownstown Police Department for a walking domestic violence complaint. The venue for this incident is 22237 Armstrong Avenue in Brownstown Township, Wayne County, Michigan. The incident occurred on October 1st, 2022, at an unknown time. The victim of this incident is Emily Ferguson, a white female born 8/16 in 1999. She resides at 17652 Harlan Street in Melvindale. Suspect is Adam Carlisle, black male, 12498, and the 22237 Armstrong Ave. Ferguson and Carlisle were in a former intimate dating relationship for 4 years. They had no children in common, and they used to reside in the same household. I interviewed Ferguson in our lobby, and she stated on Saturday, October 1st, 2022, she was physically assaulted by her ex-boyfriend, Carlisle, at his residence. Ferguson stated they were
Why
arguing
did she
about-
come into the police department?
She came to the police department on October. The incident occurred on October 1st. She came in on October 6th.
Of 22?
Yes, sir.
So why is this taking so long?
So I only discovered that this warrant was in PBK about a week ago. I was doing an audit.
What's PBK?
The Wayne County prosecutors, where you submit your cases. You submit them online
It
through.
looks like they approved it on December 17th of
They did.
22.
They did. I did not discover that this was a
Okay.
warrant
Okay.
until a
All
week
right,
ago.
go ahead.
Ferguson stated that they were arguing about ongoing person-to-man relationship when he, Carlisle, grabbed and body slammed her onto a couch. After doing this, Ferguson stated Carlisle grabbed her by her ankles and pulled her off of the couch. Ferguson stated Carlisle then started to throw boxes and dresser drawers at her. Some of these dresser drawers and boxes did strike her, causing injuries to her body. After the assault, Ferguson stated she went upstairs to get Carlisle's cousin so he could be in the room with Carlisle and herself. Instead of doing that, Carlisle and his cousin left the residence. Ferguson then took this time to collect her belongings and her animals, and she left the residence. Ferguson stated she was initially reluctant to report this assault, but after speaking with her family, she wished to file a police report. I attempted to contact the suspect Carlisle by phone twice in regards to this incident, and he did not respond to my phone calls. The victim sustained several injuries to her person because of this incident. These injuries include bruising to her right bicep and tricep, her back, and her left side. Ferguson also reported to me that she had injuries to her groin area, however, I did not observe these while I was speaking with her. I took pictures of visible injuries to Ferguson, and the pictures were saved to a DVD. Ferguson also took pictures of herself on the day of the assault. She emailed those to me, and I attached them to the DVD as well. Carlisle was run through lean, and he was found to have no criminal history.
All right, based on your sworn testimony, I find the crime of domestic violence was committed. There's probable cause to believe the defendant committed the crime. I'm going to put down an interim bond of 200. I think in fairness, though, that you should at least call and leave a message for him and tell him that he should surrender himself, that a warrant's been issued on this, okay?
Yes, sir.
Have a great day. Thank you. All right. Red Hawk Landing versus Christian Dew, 2600706. Your name, ma'am? You have to unmute.
Christian, do you?
All right, Mr. Ingram, your appearance.
Fronting over the plaintiff.
Ma'am, did you listen to and understand the rights?
Yes.
Do you intend to apply for funding, or would you like to speak to a lawyer?
Neither. We actually don't qualify for funding.
All right, Mr. Ingram, why don't you tell me what is due here?
Sure. As far as just rent, it's $6,578.73. That includes March. There then would be $170 late fee on top of that. And then there's court cost of $184.17.
All right. 6638, 6630, no, 6648, 6748, 6832.90, is that right?
That's what I've got too, Judge.
Default judgment. I'm sorry, ma'am, can you pay this amount?
So I did try to act on good faith on February the 11th to pay the January. Shauna DeCrisco, who's the leasing manager, is very well of our situation because I had been in the Mayo Clinic for the whole month of January. And I'm on long term. And 2 weeks after returning from the Mayo Clinic, my husband, who works for Lowe's Home Improvement, suffered an at-work injury that required immediate surgery. I sent her a very lengthy email trying to make good on the faith. She refused my $2,073 payment, stating that if she did it for me, she'd have to do it for others in response to my email. I also had a letter of good faith of more funds coming in that would be about the middle of February, and that was denied as well. So our lease is actually up on April the 9th. And if they take all of this money from us, we have no money to move anywhere else because unfortunately this has become our situation. I have reached out to multiple sources who state that we don't qualify for the income because we are not out on the street. We're not veterans. We don't have minor children in the home. And so
let me ask you a question, ma'am. How much were you going to give her in February? At one point in January, you were going to give her $2,073, right?
Yes. And in February, the other $2,073, I asked could she please waive the legal fees and work something out with me.
That's only $75.
No, my legal fees are well over almost $300 in legal fees is what's been added to my ledger.
Well, that's the court costs, though. They had to pay for that.
Right.
That includes court costs. You
Right.
still have
So
that 40, hang on. You still have that $4,146 that you were going to pay her that she refused?
I do, yes. And I know our lease is up on April the 9th, and unfortunately, we can't stay here because of our situation. Our rent is almost $500 more over the last 2 years. So we are going to relocate back to my home state. I've tried to do this with, to make it very simple.
I listen to me. Hang on. I am very sympathetic to what you're going through. The problem is that I can't expect them to let you live there for free.
I'm not trying to live here for free, sir.
Here's what I'm going to do. I'm going to give them their judgment, and that's going to be for $68.32.90 after hearing. And if you pay $41.50 by March 12th, writ date extended until March 26th. I can do that for you.
Okay.
So if you pay $41.50 by March the 12th, I'll extend the writ date till the 26th. You'll have to pay the rest of the rent by the 26th or vacate by the 26th. If you miss the first payment of $41.50 on March 12th, they're going to be evicted, or so you'll have to vacate if you're not going to pay that.
Understood.
Okay, do you fully understand everything?
Yes, sir, I do understand.
Do you have any questions?
No, sir, I do not.
I wish you well, really do. Good luck to you.
Thank you.
Thank you, Judge.
Red Hawk versus Kenya Taylor, 2600707. Good morning, Ms. Taylor. Your name? You're muted.
Good morning, Kenya Taylor.
Mr. Ingram, your appearance?
Front taken for plaintiff.
Did you listen to and understand the rights, Ms. Taylor?
Yes.
Do you wish to apply for funding or speak with a lawyer?
I'm going to definitely apply for funding after this, but I don't need a lawyer.
All right, I'm going to adjourn this then. You're entitled to a 2-week adjournment. I'll adjourn it to March the 16th at 10:15. Listen very carefully. You have to provide us with proof that you've made application for funding within 5 days.
I already did it. Okay, I could do that. And I'm laid off and I have the papers for that too. I'm laid off.
Hang on, slow down. So you just bring it up to the courthouse this week. Provide them with proof that you make that application. This will give you an adjournment until March 16th at 10:15. Okay?
Okay.
Any questions?
No, sir.
How much is owed, Mr. Ingram? Wait, don't go anywhere, ma'am.
No, I owe February rent. And before we.
You owe March rent now too.
I know I owe March rent, but I didn't have the court fee. This court fee is $230. I had my rent though, but I still got pushed. I might as well go to court since y'all charging me $230.
Slow down. Tell me the total amount owed, Mr. Ingram. I don't need a breakdown.
Of course, Your Honor. $46.13.59, and that includes court costs and $170 late fee.
Mhm.
And so that's what you owe. That includes the March rent. You agree with that?
Yes, but March isn't late yet, so it shouldn't have a late fee. March is late after the 3rd.
I
That's
don't
a
think he
previous
charged you
late
for
fee.
March. You didn't charge for March a late fee, did you, counsel?
No, that's a previous one, Judge.
Yeah. Okay, but the
Okay.
rent is, okay, so that's the amount you're gonna have to come up with between what you acquire with funding and what you can pay on your own. I wish you well. We'll see you March 16th at 10:15. Make sure you bring up that proof. Good luck to you. Thank you.
Thank you so much.
Court back session.
All right. Tanglewood. Tanglewood versus Diane Dickerson, 2600695. Ms. Dickerson, your name, ma'am? Dickinson. You have to unmute. You have to unmute on the bottom left-hand corner of your screen. You're muted, so I can't hear a word you're saying. Ms. Kingsley, your appearance?
Okay. Are we good now?
We are, ma'am. Your name?
Diane Dickinson?
Ms. Kingsley, your appearance?
He's talking to the attorney.
Oh.
Looking for the attorney, I think.
Linda, where's Ms. Kingsley at?
She's not in a breakout room. I don't know why she's not answering.
Ms. Kingsley. Do I have anything else? Which one do I have? Can you hand me those 1030s? There you are. Your appearance?
Good morning, Your Honor. Brianna Kingsley appearing on behalf of the plaintiff.
All right, Ms. Dickinson, your name again, ma'am.
Diane Dickinson?
Did you listen to and understand the rights on the video, ma'am?
Yes, sir.
Do you wish to speak to a lawyer or apply for funding?
No.
All right. Did you guys resolve this? I heard you were in a breakout room.
We did, Your Honor.
Okay. Is it a consent judgment or a conditional dismissal?
A consent judgment with the following terms.
Okay.
Right to retain $1,589.09. One late fee, $50. Court costs $189.79 for a total of $1,828.88. Ms. Dickinson and the occupant Brian Liss, who has consented to this as well, will pay $500 by 3/12. So long as they make that payment, they can have until 3/27 to come up with the remaining balance. And they both have provided me with permission to sign their names to the consent judgment.
When's the balance due? March
27th.
All right. Ms. Dickinson, do you agree to those terms?
Yes.
Sir, what is your name?
First name is Brian, Brian, and last name is Liss, Lis, sir.
All right. You talked to Ms. Kingsley too, and you agree to these terms as another occupant, correct?
That is correct, sir.
So you understand that the total amount due and owing, and I want you to correct me if I'm wrong, Ms. Kingsley, is $1,828.88. And you have to pay $500 by March 12th. If you do, the writ date is extended until March the 27th. You understand and agree to that, Ms. Dickinson?
Yes.
Mr. Liss?
Yes, sir.
Since you are unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment. And you have 10 days to appeal this. Do you understand that?
Yes.
Yes.
All right. Any questions, Mrs. Dickinson?
No.
Mr. Liss?
None at all, sir.
Good luck to you folks. Thank you very much. This is Concord Consumer Housing versus Amanda Mount, 2501975.
Good morning, Your Honor. Creighton Gallup, P63002 on behalf of the plaintiff.
Ms. Mount,
Amanda.
good morning. Your name?
Good morning. Amanda Mount.
And Ms. Turner, your name?
Hope Turner.
So I want you to know, I don't have to get real specific here, but I do all these on YouTube, and we're on YouTube. Okay, everybody part of my docket is. So I don't feel really comfortable taking this off YouTube. I don't have to be on YouTube, but I do for all my proceedings, and I'm not going to change that here. I've looked at your conditional dismissal, and I see that you both signed it. And essentially, Ms. Mount, did you read this really carefully?
Yeah, I read it.
I didn't hear you.
Yes.
Yeah,
Not
but
carefully.
what's that?
Not carefully, but I read it.
Well, you've been fighting these guys for 8 months, and you're telling me you didn't carefully read this? I mean,
Yeah.
you filed more pleadings. I've never had this many pleadings on a landlord tenant. Let me just be honest with you. 32 years, 31 years plus. I just want to make sure you read this and fully understand every aspect of this. Or do you want me to cover it with you?
No, I read it.
Do you fully understand every aspect of this?
Yes.
I mean, you're not a lawyer, and I just want to make sure that you fully understand, and I want to answer any questions that you might have regarding any of the language in here.
Well, I would prefer you retain jurisdiction if anything were to happen.
If they fight, which I would, you know, you guys are agreeing to dismiss your complaints and counterclaims, it says without prejudice, right, Mr. Gallup?
That's correct, Your Honor.
And you understand what without prejudice means, right, Ms. Mount? It means the claim could essentially be brought again.
Yeah.
Do you understand that?
Yes.
And do you understand that there's terms set forth here, and essentially you're agreeing to be placed on probation? I don't mean in a criminal sense, but you're on probation for 12 months, and you have to comply with all the terms and conditions of what is contained in the agreement. And you also have to comply with the bylaws and the occupancy agreement and all other documents that govern Concord Consumer Housing. Do you understand that?
Yes.
And do you understand that if they think you didn't comply with something, that they can file an affidavit and then and telling the court why you didn't comply, and then you will have to file an objection for there to be a hearing. Do you understand that?
Yes.
So if they filed an affidavit saying you didn't comply with some aspect and you didn't file an objection, they're going to be entitled to a judgment. If you file an objection, we're going to have a hearing as to whether or not you violated any of the terms of the conditional dismissal or the occupancy agreement or the bylaws or articles of incorporation or anything else that govern Concord Consumer Housing. Do you understand that?
Yes.
Now, I'm going to hope, before we go on, that we're not going to end up back in here. This has been, and again, I first of all, Ms. Mount, why are you looking at the floor?
I'm just thinking.
I want you to understand, ma'am, you have, since you're unrepresented by a lawyer, you have 3 business days to come in here and fill out a motion to set aside the judgment if you don't understand something. And you have 10 days to appeal. Those are the rules that govern entry of a consent judgment. I'm going to view the conditional dismissal the same way. Do you understand that?
Yes.
Do you have any questions for me with regard to any of this language in the conditional dismissal order addendum?
No.
So just for the record, I told you guys I took home all the information last week. You adjourned the motion for summary from last Monday to today so that you could talk further. I have the document here. I'm prepared to sign it. I just hope we're done with the case. I just really, really, really hope we're done with the case. If there's any petty nonsense that's going on either side, I'm not going to be a happy guy. And I'm going to go ahead and sign it. And we're going to go from there. Anybody want to say anything or ask me any questions before I sign?
I don't have any, Your Honor. I would just state that we did provide several drafts to Ms. Mount, and I made myself available to her, even though I'm not her counsel. And we did incorporate some last minute things to give her even more protections under paragraph 12. We extended the objection filing date by 21 days rather than 14 under the court rule. And we were serving her both by first class mail and email just to make sure that she would get it. I won't say 100%, but I'm very, very optimistic that the parties have reached an inflection point after going through this for over a year, that this is going to be a new step and a new chapter. And there are considerable protection mechanisms for both parties. And we incorporated Ms. Mount's thoughts into this as well. So this was not a project that just happened overnight. This was a work in progress over weeks.
I understand. Ms. Mount, do you have anything?
No, I just like to live in peace.
All right. How do I put this delicately? Because I don't want to say anything that's going to cause anybody to think that they're right or not right. I can tell you, Ms. Mount, if you did this stuff on your own, listen to me, look at me. You don't have a college degree, do you?
No. I am educated, though. I do have college under my belt. I was a writer.
I thought you did a really nice job.
Thank you.
I really did. Pardon me?
I've been fighting my whole life trying to raise kids.
I don't think law school, the problem with law school is it's so expensive. But you know what? There's grants out there. You never know. Don't waste your life. How old are you?
39.
You're a kid still. Don't waste your life.
Yeah.
You got some talent.
Thank you.
You really do.
Thank you.
I'm not sure, Mr. Gallup, that Concord has been, I got to tell you, I don't know if they're working on the mold remediation quick enough. Now, I don't know where they get all the money for this. I get the fact it's Section 8 housing, but this lady was displaced for 3 months. And something's got to work over there, man. Somebody's got some questions to answer. That's all I'm going to say about it. I've signed the document. I wish everybody well. And we'll go from there. I hope I don't see anybody again. Ms. Mount, if you ever want to go to law school and this case is over probation time, come talk to me. You got to wait 12 months, though.
Okay.
All right?
Okay,
good luck
thank
to all
you.
three of you. Be nice to one another. Life is too short. If events don't tell us that, I don't know what will. Even when you're 39, you think you're going to live till you're 212. At least I did, and it's not working out.
And heart
Best
failure.
of luck to everybody. Thank you.
Thanks.
Thank you, Your Honor.
Caitlin Hicks.
Ready? I'm ready to.
Object to being on YouTube right now. To start, object to being on YouTube right now to start with, because there's because we have the open courts now, COVID's over with, and I don't want anything that I'm doing here to be recorded and monetized.
Okay,
So
overruled.
I'm objecting to that to start.
Overruled. What else do you want to say?
I've filed motions for findings of fact and conclusions of law on this case months back on the expert witness and mental health expert. I filed a motion on that. I've also filed a motion to clarify what the court's order was on Rapon being the expert. I'll represent to the court. I've contacted Dr. Rapon's office. He has no order. He hasn't been contacted by the court in any way pursuant to the court's, whatever the court ruled on the last time. But I would request a ruling on that motion to clarify what the court's order was to start with, and also finding of fact and conclusions of law determination, which I also filed. That should be That was filed months back, those motions, probably at least a month ago. And there's been no determination. I was informed it was placed on your desk for determination.
It wasn't.
Well, that was what I was told. So I'm not throwing staff under the bus. But
No, you'd be the last one to do
I
it.
would be the last one to do that.
Well,
There has,
yeah,
the court wants me to proceed without an.
I didn't see this.
Yeah,
I haven't seen this, but
I've called on it, asked it to be for determination.
but that's not the way you present.
So
This is, you're presenting it now. This is the right way to do it.
no, I
Is the
tried to
present-
present it to the court
Sir?
and I called to present it.
Oh.
This is on me, Your Honor. I filed this months ago.
Sir,
In contact
sir.
the court to have rulings on this.
You're
It's
gonna
not on me.
are you through barking at this court, sir?
I'm not gonna be blamed for this.
You're not blamed for anything. There's a motion in the file. You need to present it, though, if it's a.
Attempted to do that. I did.
Here's what we're gonna do. We're gonna wait until you quit talking. Since you like to speak over the court, and both of us can't speak, as you know that. Would you be so kind as to let me complete my thought, and then you have a fair opportunity to speak? Would you follow that rule, please?
Yes.
Thank you. Thank you. Like, well, I'm gonna look at it now, but presenting it is the way you're gonna do it. When you file it, you file it. If it gets to me, it may or may not.
How am I supposed to present it? I've called and asked. I was told it was.
No,
on
no.
the desk to look at ostensibly for you to make a determination.
The things, the way that I've done it for 40 years, I learned how to do it 40 years ago. The way lawyers do it, I've got a motion here. Here it is. I'm presenting it to you. It's on the record. It's been presented. I know about it. Then I've got a rule on it. When it goes into a file, my God, you know how many files we have, 2,500.
That's why I called and that's why I was called. I called and it was told it was on your desk.
It wasn't on my desk. I would have looked at it.
Rapon doesn't have any record of either being contacted if he's supposed to be the expert. That's why I filed a motion to determine it. And also for findings of fact and conclusions of law, not to have Dr. Hanswa as a defense expert witness. I have Dr. Hanswa. I have subpoenaed him because he did treat the defendant in the past. That was his prior report from 2018 is attached to the exhibit from the motion to have him appointed as an expert witness. So there's a record of his treatment of the defendant back in 2018. And I have Hamza under subpoena, or at least Mr. Laird informed me I would have had to reserve the subpoena because it was for the previous day. But I have subpoenaed Hamza just to come in, even if not as a defense expert, but at least to testify what the defendant's mental state or mental capacity was back in 2018.
What's that important for me? You want just findings of fact, right?
There's a confession involved, and he's trying to say that there was no mental capacity to make that or to commit the crime.
I'm saying he lacked mental capacity to knowingly voluntary weapons, which is a lesser standard than just lacking complete mental capacity.
Okay. The court obviously is not going to be able to do it today. So we'll have to take some time to do it, but it's before me now. But 2,500 files, I don't go search for them, as you can imagine.
What would the court suggest I do next time in order to make sure?
What they do is I've got an order. Here it is. When it's presented, it's on the record. It's been presented, and I'm on notice. All right, we now call cause number 25 CR 1498, the state of Texas versus Jock Harris. That's you, Mr. Harris?
Yes, sir.
Present with Mr. West, your attorney, and the state's attorney. You have entered a plea of guilty to burglary of a habitation, a second-degree felony, and an agreement has been reached that whatever sentence shall not exceed a cap of 6 years in prison, which means you were looking at three options here. No less than 2, no more than 6 years confinement in prison. You could be sentenced up to 6 years in prison, and that could be suspended, and you could be placed on regular probation for up to 10 years in lieu. then you could be placed on deferred or unadjudicated probation. I think those are our options, right, everybody?
Yes, sir.
A pre-sentence report has been prepared in your case, sir, and have the parties had an opportunity to review it? Are there any corrections or changes to it?
None from the defense. None from the state judge.
Then it's made a part of the record for all purposes. I'm going to ask the attorneys to sound in. It looks like on criminal history, he has a misdemeanor 16 years ago, 15 days county jail, interfering with an emergency call. That's a misdemeanor. And then it looks like in 2009, you were placed on probation for criminal mischief.
Yes.
That was revoked and you were sentenced to 2 years on April 12th of 2010, after your probation was revoked. You were also convicted 2 months later from that probation revocation for forgery and 1 year in the state jail. My guess is that forgery was the cause of why the criminal mischief was revoked and why you were sentenced. So they put that together. So you got 2 convictions, 2 felonies of, with both of those state jails? I can't tell.
It's hard to tell from that.
It says convicted state, 1 year state jail forgery. We know that, but the criminal mischief.
Give me a second, I have to look it up. The criminal mischief was a state jail judge.
Okay.
Both of them are state
There's
jails.
2 state jail convictions and a misdemeanor conviction. Is that about right? I think everybody. All right. And this was a terrible situation, according to these facts, where on October 6th, in this case, the officers respond to a location where it is reported that the defendant was threatening to kill, looks like his mother, and break into her apartment. It states that the defendant had previously assaulted her, and that management has even changed locks to prevent him from accessing. He sent several threatening messages. They had to deploy a taser multiple times before he was restrained. There was damage. All right. He was experiencing significant stress at the time related to transportation and employment issues, which contributed to desperation. There's a broken window that would cost about $300 to fix, and then amount of some clothing was damaged by bleach, causing an estimated $500. So there's a total of $800 lost from this damage, according to the victims. And the defendant, when the probation office was completing this pre-sentence report, the victim stated that he did not want probation in this case.
You said victim, Judge. You meant
I'm sorry, the defendant did not complete the preliminary pre-sentence paperwork. He stated that he was not interested in probation. He explained that although he hoped for an incarceration sentence of less than 6 years, he did not believe he could successfully complete a 10-year probation term due to the lack of family and community support, as well as transportation and inadequate paid employment. In a statement to the court earlier, the defendant stated that if his mother had assisted him in retrieving his personal belongings from her residence, instead of ignoring him and locking him out, this current crime offense he's charged with would not have occurred. All right. Go ahead.
Your Honor, actually, everything that I had highlighted to bring to your attention is stuff you just read off the report here. Except the only thing I'm going to go to is again on the last page, I think, page 5. As the factors that might favor leniency. I'm sure the court's reviewed those or whatever. I think the big one that pops out to me is the word desperation. Everything was driven by desperation.
Hold on. We're going to that. The paragraph after that
Yes,
one that we're talking to are several factors that might caution against leniency.
Yes,
in all fairness.
Yes.
It looks like there's
good and they're both. Yes, Your Honor. But it's my job to highlight the goods. I mean, that's what I'm supposed to do.
Go ahead.
Your Honor, like as I said, it's talking about a desperation, that it was a weird family situation. He was having some issues going on his mind, caused him to break into the house and do what he did. It's not excusing it at all, but it's some things there. Talk about he was a AB student in school, just made his full band as a clarinet player.
I did too. I played the sax and the woodwinds. Okay, go ahead.
No juvenile record. As we talked about, his criminal record is minimal. There is some stuff not really egregious. So I think that's kind of leaning into the factor on this. And then, like you said earlier, he said he did not want probation, doesn't think he could finish his probation, has not finished probation in the past. So we'd be asking for something less than 6. Obviously, we're not going to ask for 2. We're not going to ask for the minimum, but somewhere between, in the range of 4. I think that would be a fair number in this case, considering the what's going on here.
How much time does he have credit, please? You know how much time you've been in jail, about how long would you say?
This makes 6 months.
About 6 months.
So 6 months. Yeah.
You okay there, buddy?
Yeah.
Hang in there.
My daughter had a sleepover this weekend, so it was
The kids
chaos at the house.
The kids ran.
Yeah.
Ransom of Red Chief. Did they take over?
Yeah.
47.
Yeah, it's close to, it's about 6 months.
Like I said, we're just asking for something in the range of 4.
Stay.
Mr. Harris is the only reason why we're all standing here. He gets there and he threatens to kill his mom. She calls the cops. He is on a tirade in which they still hear the threats that he's making. In the time frame that he's there, he really tears everything up. And what's most telling about what it is, when I originally assessed this, that this was worth 6 years, is the fact that he doesn't want probation. And Your Honor already highlighted and stole my argument that right there on page 4 in a statement to the court, the defendant asserted that if his mother had assisted him in retrieving his personal belongings instead of ignoring him and locking him out, this never would have happened. So he basically blames his mom for the fact that he had to show up, threaten to kill her, and tear up all of her stuff I don't believe in giving sympathy to somebody who does that. Who the heck does that to their mother? The only thing I can ask for in good conscience is 6 years, Judge.
And go ahead, sir. You can, whatever you want, Mr. Harris.
I don't feel it on the day, just me just being so upset at her because when I was.
Great, she's got to hear you. You have a soft voice. Yeah.
I was me doing that time when I was already going to, I was just so very so upset and hurt. Then my mother really, answering my calls. And this, when I was at work too, she could at least call me to let me know. And when I walked all the way from work till home, and I seen the doors changed, locked. And I called her from my phone about 10 times, 15 times. And I knew she wouldn't answer the phone because of a situation that we had about me, that I didn't pay her back some money. So I think she did that out of spite. I didn't have nowhere to go, anything. I just wanted to get my thing.
Why didn't you have someplace to go? Why weren't you independent? I paid my way since I was 16.
Yeah.
It wasn't hard. You got to just work.
Yeah, me having no support,
I didn't. I did my own thing. But we, day after Sunday, what's one of the commandments? Honor thy father and thy mother. That's not a suggestion.
Yeah.
That was a commandment. But I say that not to spend time on religious thought, but law is morally based from the commandments. Our law is directly based on much of the commandments. Thou shalt not steal, honor, harm no one, give each person respect, live honestly. It's all wrapped up in there. But this is your mother.
I may highlight, Judge, on page 1 that an item that wasn't objected to is the fact that the whole reason why she had him locked out of the house was the fact that he assaulted her less than 10 days before. So it's not like it's a one-time situation. And this man is violent, and he's violent towards people that
I'm trying to figure out why there was so much hostility. But it doesn't say anything about drugs. You weren't on drugs at this time? Because that explains a lot of behavior I see every day. And I'm sorry I was speaking when she can't take us both speaking at the same time. And you have a fair opportunity to respond. But too often people are in this court who are on drugs and they act bizarre. And this was bizarre here. This was very violent. And of all people to a parent, that's irrational behavior. And generally we see that with drugs. But if you weren't on drugs and you were clear-headed, other than just mad and angry, that's different. That's worse. But that's obviously it's no way to. What were any injuries to his mom? Did we have any?
I did not get a medical report, Judge, to detail that to your honor on that. Let me see if I can dig something out of the reports. There weren't any as to the October incident, the property and all that is what
Yes, it was more of threats.
And I did not get a detailed
And then
report on the
destruction.
27th.
It's just okay. Oh, after this is all over, where are you going to go to live?
We'll be homeless. Brother will be homeless.
Well, are you able to work? Are you physically able to work?
It's getting to work.
All right, well, do that, right? I did that the day I turned 16. 80 cents an hour, 3 a.m. If I can do it, anybody can do it. All you gotta do is be willing to work. And you're physically able to, right?
Yes, sir.
What trade do you have? Do you have any trade?
The trade up there, jobs here and there. I worked in department stores. I worked in plants. I worked in
Doing what? The refineries?
I was a fire watch.
What were you making? How much were you
trash
making?
collector.
How much were you making an hour at the refinery?
Well, that was years ago. That was like 2 to 1. It was like a tip job. So it was 20 an hour, I think.
Okay, that's $40,000 a year.
That was when I was like,
That's a fortune to somebody who was making 80 cents an hour.
can I mention something, young?
Mm-hmm.
Yeah, the situation with the family violence thing. It's like such trauma with me because my mother abused me when I was small. When I was in 6th grade, so that was like when I was 12 or 13.
What do you mean?
When she hit me with a woman, when I couldn't get them out from her. So all the way up to this point, I still think so. So man, I wanted
She hit you with a ring?
Yes, right. Ring on my finger. She was helping me with homework. I mean, I probably that I didn't get right. So no, it's not.
So why did she do that?
Because why would she do that?
Yeah.
Because she just.
What provoked her to do that?
Because I couldn't get them out, probably. Homework, helping me with my homework.
Oh. Mhm. Okay. Well, one bad turn doesn't deserve another one. If you knew that was wrong, why would you assault her later? Sir?
Me thinking about that situation.
Oh.
Me thinking about that situation.
Look, every kid growing up I knew got spanked sometime. It's just discipline.
That's not discipline.
There was trauma there, I can guarantee you, but that didn't mean that I'm going to spend my whole life trying to get back at my parents for discipline. That's discipline. Well, that's just, but this is all, this is really, at the end of the day, unreasonable because you had threatened her, broke into the apartment, damaged, sent threatening messages. There's an anger here that is not natural between a child and a parent. And I hope you can work that out, but that's something you're going to have to work out personally. But you didn't get to pick your parents. That was a natural event. You got to try to work things out. There's good times and bad times, but it's not going to just, there's not going to be a bolt out of the sky necessarily that's going to change. You've got to resolve it. And she. But y'all have a family that's broken. This isn't good. Like I said, you didn't get to pick your family. Nate, our creator, did that. So you're in good times and bad times. But I hope that gets resolved. What are you going to do when you're released? Where are you going to go?
Let me go search my church, see if I can get some.
You're going to live in this area?
You live in Bowman, yes.
Okay. All right, anything else? And John, again, I know what the state's asking. What are you asking? Sir?
4.
All right, and if nothing further than this, I'm going to find Mr. Harris, you have pleaded guilty, in this case voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. And I'm going to follow this agreement You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. You'll be given credit for term all time you have served in accordance with this case. Do you understand what has happened today, sir?
Yes, sir.
When you were released, try to make peace with your family.
Yes, sir.
You only have family that the Creator gave you.
Yes, sir.
And there was an intent for that. So fix it. Okay. Thank you. Anything else, John? We've got something. Y'all ready?
Yes, John.
Go ahead.
Brittany Davis. Good morning, ma'am. Are you Brittany Davis?
Yes.
And Miss Davis, did you get someone hired?
No, it's kind of expensive, but
Who'd you-
really expensive. I'm not even working right now. But I went through
Who'd you talk to?
the legal aid. I put in an application for legal aid.
Okay.
It's a place that help you get a lawyer, but they say it could take 6 months to a year. So
Okay, so did you talk to any other lawyers like I told you to?
the first 3 that I talked to, wow, I talked to like probably 8 of them. But the lowest there goes like 2,000 to start off.
Do you have the names of the lawyers that I asked you to, that you talked to?
You asked me that last time. I was on.
Right, and then I reset you to talk to them more or get someone hired. So
I
did you
talked to
talk?
Renshaw. I talked. I can't remember their name. Renshaw. There's one that's brothers.
Why wouldn't you write that down and bring it?
I wasn't expecting that I had to.
So it looks like you weren't what?
I wasn't expecting that I had to.
So if you're okay. If I tell you to go talk to some lawyers and bring me the names of the lawyers you've talked to, and you don't think you can remember them, then I would think just common sense would tell you to write them down so that you could tell me that you did what I ordered you to do so that you wouldn't go back to jail, right?
I did do what you ordered me to do.
Okay,
The
so
first time.
I ordered you to bring back the names as well, not just talk to them, but bring back who you talked to so that I know who you talked to and that you're doing what I asked you to do, right? Right.
The cheapest ones that I've given you the last time I was here is the main ones that I was looking into.
Okay. But when you left last time, I gave you specific instructions,
Okay.
right?
Right.
Okay. So are you wearing your drug patch?
Yes, ma'am.
So it looks like back on. Second. So you tested positive since you've had that drug patch on for methamphetamine.
What is that?
What does that mean?
I don't. But what with the patch?
Mm-hmm. Looks like you tested positive for methamphetamine, cocaine. Hold on. Let me print it out so I can read it better. So last time you were in here, you had an issue because you had showed up with your drug patch in your hand, so they couldn't test it. So I tested you in court, and then I made you get the drug patch put on again and told you to keep it on. And then the drug patch that was put on January 25th. Which was the day before that court date. So you had one on, you had taken it in, you put it on, tested positive for methamphetamine and cocaine. Have a seat in the jury box. I'm going to have you tested this morning, and then I'll decide what to do. Thanks. Actually, come on, ma'am. Come on back up here. I know what I'm going to do. So, Ms. Davis, obviously it is a violation of your bond conditions to use any illegal substances, right? And so you tested positive for cocaine and methamphetamine on that drug patch, in addition to in the past not having it on correctly, and you didn't do what I asked you to do or ordered you to do also here. So I'm going to raise your bond at this time for those violations to $100,000. You will keep your court-appointed attorney while you're in custody. They'll be out to see you, and we'll just see what we do with your case at that point. You can go back with the bailiff.
Wow.
Ma'am, come on back again.
Oh, you want an example out of it? Let's see.
I'll make an example out of
I mean, I
anybody.
don't
Hang
see
on.
how you so.
You want to stand here?
You don't.
You want to stand here and be disrespectful?
No,
I
just
will
want
make
you
an
to
example.
understand my situation. Like,
I don't care what your
I'm not
situation.
making no excuses.
Okay.
I take accountability.
Right. So you tested positive for methamphetamine and cocaine.
I don't know how to patch work, ma'am. I haven't been doing any drugs.
Well, you did something.
I don't know if that's like the patch pick up sweat. I don't know if that's like after the process or what, but I haven't been doing anything.
All right. Go back with the bailiff. John, Richard.
Have an open plea, route to all counts in the, motion.
But no agreement.
No, Your Honor.
Okay. Get that. Good morning. Are you Ahmad LeBlanc?
Yes, Your Honor.
Mr. LeBlanc, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you. You can put your name on. And will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. LeBlanc, in cause number 21-36444, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 19th of 2021 for aggravated assault, a second-degree felony, and that was a 5-year deferred probation. Is that correct?
Yes, Your Honor.
It alleges that you violated your probation. Count 1 alleges that you committed a new offense of possession of a controlled substance, penalty group 2, September 1st of 2025 in Chambers County, Texas. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample August 3rd of 2022 that tested positive for marijuana. Is that true or not true? And then count 3 alleges that you're behind in your court assessed fees as of December 10th of 2025 in the amount of $480. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
True.
Did you plead true to those counts because they're all actually true?
Yes, Your Honor.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case for sentencing so that we can get an updated pre-sentence report. And then we'll go forward with sentencing. Before I let you go today, however, I'm going to get a drug test here in court. I want you to have a seat in the jury box and let's get that drug test done.
He does have a drug patch.
Okay. Thanks. Good morning. Are you Fabian Hall? And Mr. Hall was previously in court, entered a plea of guilty to the 3rd-degree felony offense of injury to a child, elderly or disabled person. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
I have. Are there any additions or corrections?
No, Your Honor.
Explanations?
Yeah.
The PSI kind of gives me some hesitancy.
It gives me a lot of hesitancy.
His response when he was given an opportunity seemed to overwhelmingly mitigate and minimize his role in this offense. Obviously, from the perspective as Mr. Riley writes it, that he has no criminal history, doesn't appear to have a substance abuse issue, so to speak, that he would be a candidate for promotion, but based on the totality of everything, and especially Judge, his evaluation of the alternates, I defer to what.
And I would also comment that the PSI itself talks about the fact that there's several factors in the defendant's background circumstances that favor leniency in sentencing.
Well,
And
all of that depends on, he pled guilty. to this. And then his version is, I was being a good father that I am. I took the kids to play. We laughed, we ate, we enjoyed. My daughter was feeling bad and I ignored the signs of sickness. She had a lacerated liver. And the allegation is that he kicked her. There's nothing in here. This is a complete denial of.
No, it wasn't meant to. I talked to him extensively about that, Judge. What he tells me, and I have not talked to the probation department who wrote that, is that, and what he would tell you, that he never understood the officer to ask him specifically what is his version.
This is
of this
his
case.
writing. He wrote this.
And then he wrote this because he explained to you why. Go ahead.
Okay, so he asked me if there was anything else I wanted to say. I'll just let him know that yeah, I'm a good father and I do what I can for my kids. That was all.
But you were not denying the fact that you committed the offense.
So did you or did you not?
Oh yeah, that's what I was saying. Yeah, I plead guilty to yes.
I know you pled guilty. I was here for that. Did you do what they charged you with? So what is the status now as far as access to children? It looks like there wasn't cooperation with Child Protective Service, which also gives me some concern. What do you see your children now?
Yeah, I do.
Do you have a court order?
Not the one that I'm not supposed to.
No, I'm talking about a court order from family court or anything that day.
Did you go through family?
Like visitation?
No, I wasn't given it.
Okay.
So you've got 5 children. And this says you live with your girlfriend and 4 of the children. Is that correct?
Yes.
But you did not complete the CPS service plan? CPS got involved, right?
Yes, ma'am.
And from what I'm reading, it looks like there was some resistance to following all of the recommendations and service plan from CPS. So
no resistance. I followed everything they asked me for.
Yeah, that was a surprise to us. Is we had understood he had done everything they asked him to do under the family plan.
and so does CPS, did they give you permission to be
They told me I would
with your children?
will have to be supervised with it, and I have been getting supervised. They never told me anything out of ordinary.
So you're never at home with these children by themselves?
No. And I'm always at work, so never at home by myself.
Where's the 5th child? There's 5 and you live with 4?
Yes, ma'am.
Which one do you not live with?
No, that's Nakai Fields.
And who does Nakaya live with? Do you see her?
No, ma'am. They wanted me not to.
Right, so that's the victim in this office.
Yes.
So with CPS, what exactly did you do? Did you take a parenting class?
No.
You did not?
No, I really didn't know what I had to do. Nobody told me nothing. That's why I'm kind of confused about it.
Judge, if the court needs more information about that, it'd be very easy for me to obtain. If you might give us either a little bit of time this morning.
And we have no problem. As a condition of probation, we have no problem as a condition of probation, saying that he must complete the recommendations of the CPS as far as like a family plan or anything.
Well, and I don't know what their recommendations are at this point, and it doesn't necessarily look to me if it's, anyway, so here's what I'm gonna do. I'm gonna find Mr. Hall that you previously entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. I'm going to follow the agreement that you made with the district attorney. I'm going to defer all proceedings and place you on probation for 7 years. You're ordered to pay a $1,500 fine and to follow all of the rules and conditions of probation. That includes entering and successfully completing a parenting course that is approved by probation. So at this point, since I'm not real sure where CPS is on this, I'm going to order myself that you do the parenting class. if CPS is still involved, I'm also going to order that you follow all of their rules and conditions, which does include that you not have contact with Nakia, and that you have no unsupervised contact with any child, including any of your own.
Yes, ma'am.
So if mom has to go out and go to the store, you don't get to stay home with the kids. Do you understand?
Yes, ma'am.
If you do, then it's a violation of this probation. You'll be right back here in court. If I find out about it, you could go to prison for up to 10 years. Do you understand? If you do everything that you're supposed to on this probation and figure out, obviously, better ways to handle the children, then at some point, if you've completed all the classes and done everything that you're supposed to, there's the possibility of some further contact with your children. And this is an opportunity where you don't have this felony conviction on your record. And at the end of the probation, if you successfully complete it, the case will be dismissed. You'll never have this conviction. The other side of that, though, like I said, is if you violate any condition of probation, you'll be back here in court and you could be facing the 10-year sentence and the conviction. Do you understand? Or up to a 10-year sentence. I do want to make sure, it looks like if there is a referral for mental health services, you have to follow through with any of those, whether you feel like you need it or not. If probation has you assessed and they feel like there's some counseling or something that would help you, you will be required to do that. Also, you will be required to have a substance abuse assessment and follow any recommendations of that. So it looks like there has been some marijuana use in the past. And that for some reason is on, when's the last time you used marijuana?
Last year, say December.
So if I test you today, you shouldn't have anything in your system. Have a signature box. Let's test that before I go any further. Do some drug tests today.
That's what you're on.
Yes. Mr. Kevin Lane on Ahmad LeBlanc. All right, so on Mr. LeBlanc's case, which is 21-36444, we went through the motion already, which is a motion to revoke unadjudicated probation, where Mr. LeBlanc is on probation for the second-degree felony offense of aggravated assault. He pled not true to counts pled true to counts 1, 2, and 3. I got a drug test done. Mr. LeBlanc tested positive for THC. And so obviously, when's the last time you smoked marijuana?
The day I had to turn myself in for the probation.
What made you think that would be a great idea? So he pled true to a possession of a controlled substance, a new offense, tested positive. So at this time, Mr. LeBlanc, you're on probation already. I granted you a bond because of that deferred probation status, but the fact that you're on probation and on bond and testing positive for THC, there's clearly an issue. At this time, I'm going to find that it is in the best interest of you and the community that there is not going to be a bond. I'm going to withdraw your bond at this time and find those violations. And then what I'm going to do is have probation do an updated report. You've pled true that obviously there's an issue. There's a new felony offense. And so we'll get an updated report and then we'll see what we're going to do at your probation sentencing. Okay, you can go back with the bailiff. So that makes me concerned, obviously, about the decision making. So what I'm going to do, Mr. Hall, I'm going to follow the agreement that you're making, but I'm going to add, and I had already gone through all of that, correct?
Yes.
So in addition to the 7 years deferred probation, the $1,500 fine, the parenting class following CPS orders and all of that, I'm going to order that you enter and successfully complete the substance abuse track of the ISF program. That means you will go into custody today. And you will complete the ISF program. And when you get out, you will do JCDI as your aftercare, which is an outpatient treatment program. Obviously, if you are doing and around people that are smoking marijuana and you've got 4 kids living with, where were your kids yesterday at the barbecue? Were they with you all?
No, they wasn't wrong.
They were. So instead of being the good dad that you're saying you are, you're out at a barbecue without your family.
No, the family was there, not around me though.
Okay, so your kids were there, but they weren't around the people smoking marijuana. Okay. That sounds ridiculous, doesn't it?
No, I'm being honest. I'm serious.
Okay, well, you're gonna enter again, we're gonna hopefully get some better decision making done. If not, you're gonna end up back in here if you violate any condition of probation, if you test positive for marijuana, if you violate any of these other rules, you'll be back here in court and you'll be looking at a sentence between 2 years and up to 10 years. I'm handing you the trial flip certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You're gonna go with the bailiff. I think have a seat in the jury box so probation can go over that paperwork. All right, go back with the bailiff, sir.
Every single person who came before Judge West, and I remember her name now. I remember her name. But every single person just about who went before Judge West today left with the bailiff. It was kind of crazy. Ladies and gentlemen, thank you so very much for hanging out with me. There's a lot more from today. I got another 2 hours I could show, but we've got to stop there. I'm saving a really, really good civil protection order case from Thurston until Saturday. We've already got almost half of the show done for Saturday, ready to go. So just mark it down. The weekend review has already begun. And boys and girls, it's a good one. Oh, wow. It's something I want all of you to be there to chat with me about it. So come on by Saturday and every night the rest of the week. You know, we do the same Wolf Time, same Wolf channel, 8 p.m. Central, 9 p.m. Eastern, all the good stuff. I'm your Lone Wolf Oozle. I'm your host for these here little get-togethers where we chat about the daily court happenings from around YouTube. And I'm your curator for this here channel at the Court Gallery. And ladies and gentlemen, you are the gasoline that powers my engine. I want to thank every single one of you. Eileen, thank you for being out there tonight. Mama Wolfie, thank you for being out there tonight. Math Girl, same to you. Crazy Rider, same to you. Florida Punk, Felix, oh boy. Bromiticus, it's good to see you as always. Twitchy Sketch, I got to scroll up a little bit, people. Mary Beth, I'm so happy to see you tonight. Ladies and gentlemen, I cannot say all these names. JB, GB, I don't know, Dave. It wasn't me. It wasn't me. It wasn't me. Rhonda, thank you for the help. You're all amazing. I'll see you next time. Later, kids. I am out. Thank you for being here, Charlene. Thank you all for being here. I'm done. In the words of the immortal Sam Beckett, oh boy.